ha Ghanatube so news edikan ekoba ewo omanimano ena yɛkɔhwehwɛ na papa na asɛm so na yɛde abrɛ ahwɛfo na muhu na mate nsɛm yɛkɔso ene de ɛba ewo ɔmannimu na emum ne nsɛm ne bo hɔ na sɛ ebeto dwa mu eyedu sɛ mu efrem sɛ yɛn ebe de ebetena se na akaka de yɛnzu yɛpɛ edi amamunti ne de ɛsɛ mamu bɛkɔ ahotie nsɛm yɛkɔso ene de ɛba ewo ɔmannimu.
The Chief Justice, the Leadership Justice, Torkornoo. Today, from the details that we got from the Deputy Attorney General, has headed to the ECOWAS Community Court alleging human rights violations in the ongoing impeachment process against him. We'll tell you exactly how things are playing out. There's very little detail, very little detail. I would say reducted detail of what we do know of the release. For instance, she's seeking in this application and the shoot before the ECOWAS court. But as I indicated, this is a rolling stone that continues to gather various forms of dust and as the days go by. But the suspended Chief Justice, Torkornoo, has taken her case to the ECOWAS Community Court in Nigeria, specifically Abuja. Now, the case was filed July 4, petitioning the court regarding human rights violations in her impeachment trial. Now, this position that she has taken is not new in the true sense of the word, because the human rights violations, she talked about it, she detailed it in that press conference that she addressed a couple of weeks ago. There is also this human rights violations as well captured in an application that she also sent to the Supreme Court, and that's why my colleague Dennis Pobert, Wadam Esquire, is joining me in the studio to chronicle how the events are played out and how that weaves into what Her Ladyship Justice Torkornoo has taken to the ECOWAS court. Then it's good to have you as always.
Alfred, always a pleasure being here.
There's very little detail we know about what Her Ladyship Justice Torkornoo has taken to the ECOWAS Community Court, is it not?
Precisely so, and this is because this was only made available to the public through the Deputy Attorney General, the learned Dr. Justice Remsai, on social media, where he did indicate that there's a pending suit at the ECOWAS Community Courts, which is in respect of matters that are already been litigated in the local courts. As he himself would characterize or summarize the essence of the whole suit, he simply says that he can confirm that the Chief Justice, Her Ladyship Justice Torkornoo, has filed another court case, this time at the ECOWAS Community Courts in Abuja, Nigeria, against the Republic. Of course, once against the Republic, the Attorney General will be in the know.
Absolutely.
And I guess on that basis that he has the information for which he's sharing with the public. That's in the case which was filed on July 4 days ago. Her Ladyship repeated the same allegations of human rights violations which are currently pending determination before our Supreme Court and also before our High Court in respect of ongoing removal processes. Essentially, Her Ladyship argues that by her suspension, she has effectively been removed from her official capacity without a final determination, impairing her right to function and serve in a position she was constitutionally appointed to. So that is the update that the Deputy Attorney General has given to the general public by way of the move that the suspended Chief Justice, Her Ladyship, has taken in line of, in an attempt to seek a remedy. We do know this is not the first time, and that's why we are just having a recall of some of the steps that she's taken in the past, specifically those that she herself has been named as the person who is taking that particular step. So we do recall that on the 20th of May 2025, that's this year of course, Her Ladyship filed a writ of summons at the Supreme Court. That matter is yet to be determined, and this is a matter in which she's seeking reliefs, including a determination as to the constitutionality or the lawfulness or otherwise of the procedure that she's taken through. It also talks about matters that relate to her suspension, where she makes an argument that that suspension need not be, it was not carried out.
For any for and some I so any day by our money more can any no and I was so a good out team. Measure pants with now so I enjoy our for and some who now jar fair Eddie mammy our comment section hall. Young quay, you could see any at so.
lawfully.
Right.
That matter is yet to be determined. However, subsequent to this, there was also an injunction application which was heard and dismissed unanimously by the Supreme Court.
True.
That was done the same day. As in, I mean, those two were filed the same day, but determination were on later dates. We also know of a judicial review at the High Court, which is pending. That was filed on the 9th of June 2025. This only came to the attention of the public when she addressed the general public in that address, press conference, where she disclosed that by the nature of the proceedings, she feels slighted, that her human rights have been violated. She makes a case of how her lawyers were not given audience, even how she herself was searched in a certain manner. She was not allowed to attend the proceedings with family, even how parties to the suit, including herself and her lawyers, were not served copies of the petition and other documents that were necessary for that. And to that extent, she has headed to the High Court seeking a judicial review in respect of that particular matter. So, in essence, saying that the High Court should make a pronouncement that the whole procedure is null and void because it infringes on her rights to fair hearing and the like. And
this is still centered on her human rights.
Yes. This is
so clearly, we can infer, okay, or have an idea of what she's seeking at the ECOWAS court, which may not be very different from what is captured in here, because it's all on the lines of the violation of her human rights, is it not?
Exactly the point that the Deputy Attorney General makes when he says that the Chief Justice has says that her ladyship repeated the same allegations of human rights violations, which are currently pending determination before Supreme Court and also before our High Court. So in respect of the High Court, you get the sense that it is in respect of the judicial review that has been talked about, because as far as we know, the only process that the Chief Justice has before the High Court is this judicial review application, which is yet to be determined. You see that the Deputy Attorney General talks about pending matters. And of course, also in respect of the Supreme Court, even though the injunction application has been determined, the substantive matter is yet to be determined. And that in part will address the issue of whether or not there were violations as regards the whole process and the things that she was asking for, including to be given copies, what she says she was not giving copies and all that, amount to violation of her rights.
But, the question was asked. You recall, after that address, when she made a point about not being given copies, the emphasis was on the fact that, yes, the president had given her copies, correct?
Yes.
Of the petitions against her. But then again, she wasn't sure whether the copies she had was the same copies that the committee members were using for the process, the hearing process. And so she requested for the copies that the committee members were using for that.
I mean, that is spot on, because her contention right from the outset has never been the fact that she's not been given copies from the presidency, because, of course, there's correspondence between herself and the presidency.
Absolutely.
However, her contention has always been the fact that the forum before which she appears to be taken through the process, she was not served the copies that were before that committee. So she was talking about copies from the committee and not necessarily copies from the presidency.
But you are an officer of the court.
But of course, that is a matter which is yet to be determined.
Absolutely.
And when that determination is made as to whether the copies that are given from the presidency could actually be a substitute for the copies that she required before the committee, that is a matter that will actually be settled in respect of that. But she is of the view that to the extent that she did not get those copies, in a sense, it's a violation of her human rights.
I see.
And that's the reason for which she's before the High Courts in Ghana. Now she's taking another step before the ECOWAS community courts in Nigeria in particular. So let's continue with this, because that's not the only. So the judicial review was on the 9th of June 2025. So now, yes, we are here. July 4, we understand that that has been said. But it's important to state that in terms of general attempts that have been made to stop this process, her injunction application, which was filed on 21st May 2025, was the fifth of injunction applications to be brought before the Supreme Court, all in an attempt to halt the process.
Right.
It's important to state on record that all have failed.
So what is pending is this sixth one?
So what is pending now is the substantive matter in her own case. In fact, all the substantive matters are still pending, except, usually you deal with the injunction before they go into the substantive case. So the substantive matters are still pending, but the injunction applications have been dealt with. But injunction applications, I did indicate, seeking to stop the process. 5 of them
have all failed.
So we look forward to see what's going to happen. But we understand there's a new development on this particular matter.
Indeed. And rightly so, we're going to get into it shortly, because what we do know is that
for any for some I so any day by our money can't any no, and I was so a good out team. Measure pants a witty now, so I enjoy our for and some who now would jar a fair Eddie and Mammy, our comment section hall. Young Quay, and you could see any at so.
Earlier today, the President, John Dramani Mahama, has been speaking about the processes, essentially seeking the removal of the Chief Justice, who is on suspension now, the Leadership Justice Ghanatube Torkornoo, and addressing the members of the Council of State earlier today. The President indicated that he, together with the Council of State, they're just waiting for the committee hearing the Chief Justice's petitions to submit their report, and then they'll know what next step to take. Take a look.
Your work in earnest, as the chairman of the council has stated. We've referred several things to the council for advice, mostly in respect of appointments to governing boards and other statutory institutions. And I want to thank you for the approvals you have given us and for expediting the work of government. It's helped us to more speedily than any government in the past have persons in place to begin to prosecute the reset agenda that we have. On the issue of governance, we've had a difficult issue with regards to the suspension of the Chief Justice, and of course the Council of State was involved in a part of that process, and so we've done our part. The rest is left with the committee that was set up to come out with whatever its findings are, and based on that, whatever the consequential issues are will be dealt with.
Oh, that's the President, John Dramani Mahama there. So what is left now is he's, together with the Council of State, he is waiting for the report of this committee set up to hear the Chief Justice, the petitions against him. But if the report is submitted, then what next?
Well, so Alfred, let's start from here. So when you look at the entire Article 146, we've gone through quite the most parts of it. What we are dealing with now is the 146(8), which talks about the proceedings. And this is where most of the issues came about, including the allegations of human rights violations and the like. So once the committee is done, because the 9 is very short, we need to take it up from the 8 so that we can put things to proper context. 8 talks about that all proceedings under this article shall be in camera, and the justice or the chairperson against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other aspects of his choice. Now it continues to say, the president shall, in each case, act in accordance with the recommendations of the committee. So what you hear the president say is that yes, he acknowledges that this process is ongoing, and what he's now waiting for is the fact that he's waiting for the committee to make its recommendations that will be contained in the report. Right. Now, when that recommendations are made, the provision says that the president shall act in accordance with the recommendations of the committee.
The emphasis on the shall.
Shall. And he was talking to the Council of States, the people with whom he consulted to, at the beginning of this matter, to make the determination of the prima facie case based on which the matter was referred to the committee and all that. So that's why you hear him say that since they were part of this process, he's only mentioning to them that he's now expecting that report, and then we'll see what the next line of action is. And as I indicated, the next line of action when the report is ready or the recommendations are ready is what is provided for under Article 1469 of the 1992 Constitution.
That's what you have behind you.
Yeah.
Some great detail there. Dennis Pabari Wadamesco, I appreciate you as always, walking us through the process and making it.
For any for and some I also any day by our money more can any and I was so a good out team. Measure pants with now, so I enjoy our for and some who now jar the fair Eddie Mammy, our comment section hall. Young quay, you could see any at so
simple to understand.
Thank you for having me, Alfred.
Appreciate you. Now let's stay a bit further on this. And Kwekwansa Sari is a private legal practitioner and then also the former director of the Ghana School of Law. He's joining us on the telephone for a quick conversation. Appreciate you, sir. Thank you for joining us. I mean, how does this strike you, this latest decision by her ladyship Justice Torkornoo to take her issues to the ECOWAS court to seek justice for what she says is the violation of her human rights by this entire process to have her removed?
Oh, thank you. I think that the Chief Justice is now holding on to just anything, that will come their way. The ECOWAS Community Court indeed has jurisdiction to hear the cases bordering on violations of individual human rights. But the point is that the ECOWAS Community Court is a creature of the ECOWAS community pursuant to their own protocols and treaties. And the first thing presumptively is that the ECOWAS Community Court will respect the laws of member states. And one of the laws, the member states, is reserved for each other's, sovereignty. Indeed, the Lady Chief Justice, may take cases, to any court, even, go to the World Court, the Hague, anywhere. But the primary question is, has she exhausted, all the internal mechanisms here in Ghana? This is something that I find very difficult to understand. She's the Chief Justice. She has to respect the Article 146 CJ removal process. If she herself is disrespecting, the Article 146 CJ removal process, how does she expect the ECOWAS Community Court to intervene? Because first of all, they may, like to find out whether, there are any internal mechanisms in Ghana available. Are there remedies? Are there justiciable remedies? Now, this is a process that has been triggered under a constitution promulgated by the people, of Ghana for themselves, for the good governance of, the entire nation. She is the Chief Justice. And if she is not, prepared and willing to respect, own constitution, how does she expect ECOWAS, to intervene to protect her? I don't think that, the case is going to succeed. This is again one of the, cases with the dimmest prospect of success. It's doomed to failure, because the ECOWAS court indeed, it's a well-respected international adjudicatory body. But if you look at, what it has done in the past, it has, not simply interfered, with the internal processes. It only assumes jurisdiction in clear cases of violation of human rights. Here, I can't find any, human rights violation, perpetrated against Chief Justice Torkornoo. I think once again, is a very bad approach.
If you say it's a very bad approach, and from you indicate that the ECOWAS court would only pay attention to such matters if they, per their own consideration, the person who's brought the case to them has exhausted all internal avenues for redress or, as it were, remedy. But from where you sit, would you say that the suspended Chief Justice has not exhausted all the internal avenues for redress or the remedy to this situation of the, what she says, the violation of her human rights, because she's taking the matter to the Supreme Court? It didn't go through. This injunction didn't succeed. She's at the High Court now seeking a judicial review as well. What else has not been done internally?
Again, you see, the office of Chief Justice is not, an individual's personal property. So this matter is not a personal matter. This is a constitutional process. Article 146 has been triggered by virtue of the submission of petitions to His Excellency, the President of the Republic. In every step taken, the President has respected the Constitution and actually acted in accordance with the provisions of the Constitution. There has been no clear case of violation of any human rights of Lady Torkornoo. The President has not breached any rule. If anything at all, the President has observed, the framework, that the framers of the Constitution put in place, that if you receive a petition, these are the constitutional steps you should take. And on each pathway, you have to respect, the will of the people as enshrined in the Constitution. The President has done that. It is the Chief Justice who has created a condition of, rendering the process, impracticable. Today, she does this. Tomorrow, she goes to Abidjan. Another time, she'll go to Togo and this thing. So, if you create conditions, that, render it impossible, to hear the case, the case or the petitions brought before the committee set up by the President in consultation with the Council of State, then it is she who is, rendering, the pathway intractable. Not the President, not the people of Ghana. So she must allow, the constitutional process already triggered by the President, pursuant to the submission of the petitions, to, go to completion. Once the processes are determined judicially in accordance, with the framework spelled out clearly in Article 146, then and only then can one determine whether human rights are being violated or not. The ECOWAS Community Court has, on a number of occasions, dismissed suits, filed by aggrieved persons. On, certain occasions, it has, allowed, suits. But in all these things, the question is, have you exhausted the internal remedies provided by your own law?
Right. And I do appreciate your thoughts on this. And as I indicated, this new development is also attracting divergent views on whether or not this would go through or receive the attention of the ECOWAS court. Quick, I appreciate your time. Thank you, sir. Thank you so much for joining us. He is a former director of the Ghana School of Law, and also Professor Kojo Apieje-Etia, who is a professor of law at the University of Ghana.
For anything for her, and I'm from the if I was at a seminar show, and if I had a Ghanatube.